I think recording has started. You can start now.
Good afternoon, everybody. Today we will be having a roundtable conference convened to deliberate upon the recent judicial pronouncement, the Supriyo versus Union of India judgment. This legal discourse assumes paramount significance as it addresses the intricate facets of the LGBTQIA plus rights within the framework of the Indian jurisprudence. The Supreme case, adjudicated by a panel of five eminent justices, emerges as a watershed moment in the evolving legal discourses surrounding the LGBTQIA community. The judgment, characterized by its diversity of opinions, encapsulates a legal dialogue that extends beyond the specificity of the case to encompass broader questions pertinent to constitutional interpretation, human rights, and the ongoing pursuit of equality. The deliberations today will navigate the legal intricacies delineated by the Supreme Court, scrutinizing the unanimous findings, concurring perspectives, and the dissenting viewpoints that highlight the complexity surrounding the acknowledgement of the right to marry within the LGBTQIA community. This conference aspires not only to dissect the legal rationale underpinning the judgment, but also to contextualize the Supreme case within the broader trajectory of the LGBTQIA rights subsequent to the pivotal Navtej Singh Johar judgment. In the course of our discussions, we aim to probe the broader implications of the Supreme judgment and the future landscape of marriage equality in India. What legal precedents does it establish? How does it align with the constitutional principles of privacy, autonomy, and equality? What role does the judiciary play in shaping societal attitudes? And to what extent might the legislative reforms be requisite to harmonize laws with the evolving norms? This brings us to the first question of today's discussion, which is essentially pertinent to what the Supreme versus Union judgment was in brief.
Hi everyone, I would be taking the first question, which is about discussing the Supriya versus Union of India judgment in brief. So I would be laying the background for the discussion for the further questions. So on November 14, 2022, two same-sex couples filed writ petition in the Supreme Court seeking legal recognition of their same-sex marriage in India. The petition was centered around the constitutionality of the Special Marriage Act. The petitioners argued that the Section 4 Clause C of the Act recognizes marriage only between a male and female. So, this essentially discriminates same sex couples by denying them matrimonial benefits such as adoption, surrogacy, employment, and retirement benefits. So, the petitioner asked the court to declare Section 4 Clause C of the Act unconstitutional. The plea has been also been tagged with number of other petitions challenging other personal laws on similar grounds. The challenged enactments include the Hindu Marriage Act and Foreign Marriage Act. However, in this case, the Constitution Bench of the Honorable Supreme Court gave judgment on October 17, 2023, and has declined to recognize right of same-sex couple to marry or have civil union. The Constitution Bench comprised of Honorable Chief Justice of India, D.Y. Chandrachud, Justice S.K. Kaul, Justice S. Ravindra Bhatt, Justice Hima Kohli, and Justice P.S. Narasimha delivered four separate judgments. The majority opinion was essentially delivered by Justice Bhatt and Justice Kohli, with Justice Narasimha delivering a separate concurring opinion. However, CJI D.Y. Chandrachud and Justice S.K. Kaul each penned a dissenting judgment. So all the judges unanimously agreed that there is no absolute right to marriage, and same-sex couple cannot assert it as a fundamental right. And the Supreme Court also unanimously rejected the challenge to provisions of Special Marriage Act. So the majority judges also asserted that the civil unions between same-sex couples are not legally recognized and that they cannot claim the right to adopt children. So there are few of the key takeaways from the judgments. So I will be discussing those key takeaways from the judgment. Firstly, it was held that there is no inherent right to marriage, that the marriage is not an inherent unqualified right, but rather one subject to statutes and customs. Also, the legal recognition of civil unions akin to marriage can only be established through enacted laws. The court cannot mandate or create such a legal status. Also, the court held that there is no legal status for queer couples. Queer couples have the right to form emotional, mental, or sexual relationships, drawing from the right to privacy, choice, and autonomy. However, this does not grant them legal status or entitlement to union of marriage. The court also discussed the validity of Special Marriage Act. The challenge to the Special Marriage Act in terms of recognizing same-sex union was dismissed. Also, indirect discrimination affecting queer couples regarding entitlement to compensatory benefits or welfare entitlements tied to marital status should be addressed and eliminated by the central government. This was held by the Supreme Court. Also, the Supreme Court held that the establishment of high-powered committee, a high-powered committee chaired by the cabinet secretary appointed by the central government, should comprehensively examine factors related to same-sex marriage, should comprehensively examine factors related to same-sex marriage, considering the inputs of all stakeholders, states, and union territories. The court also held regarding the transgender person right to marry. So the transgender individuals in heterosexual relationships are free to marry. Also, there is no right to adopt children according to the court. Under current law, queer people do not have the right to adopt. However, Regulation 5 Clause 3 of CARA regulations, which bars unmarried individuals from adopting, is upheld. However, CARA and central government should consider the implications for de facto families where single individuals are allowed to adopt and subsequently enter non-matrimonial relationships. The court also held that the protection against held about the protection against involuntary medical treatments. So the court held that the state must ensure that the cohabitation rights of queer people are not violated, and the steps should be taken to prevent involuntary medical or surgical treatments of queer and transgender individuals. So this was the judgment in very brief. So over to the next person for discussing second question.
Thank you so much, Diksha. This was very informative and helpful. We move on to the second question, which is to what extent did the Navtej Singh Johar versus Union of India judgment form a legal precedent that influenced the outcome of the Supriyo versus Union of India case? So essentially, the Navtej Singh Johar versus Union of India judgment was delivered by the Supreme Court of India in 2018, and it played a crucial role in shaping the legal landscape regarding the same-sex marriage rights, particularly in the context of decriminalizing consensual same-sex relations. In the Navtej Singh Johar case, the Supreme Court, led by Chief Justice Deepak Mishra, struck down Section 377 of the Indian Penal Code, which criminalized homosexual acts between consenting adults. This landmark decision marked a significant departure from the earlier jurisprudential stance and established a foundation for recognizing the rights and dignity of the LGBTQIA+ community. The Navtej Singh Johar judgment had a profound impact on the legal understanding of what are the rights of the LGBTQIA+ community and set a precedent that undoubtedly influenced the subsequent Supriyo versus Union of India judgment. The Supriyo case, which addressed the right of the LGBTQIA+ community to marry, was heard against the backdrop of the evolving legal landscape established by the Navtej Singh Johar judgment. The several key aspects of the Navtej Singh Johar case contributed to the legal framework that the Supreme Court considered in the Supriyo case. First and foremost, the Navtej Singh Johar judgment explicitly recognized the right to privacy, autonomy, and dignity as inherent components of the right to life and personal liberty under Article 21 of the Constitution of India. This recognition formed a crucial foundation for the arguments related to the intimate associations and relationships, including the right to marry in the Supriyo case. The acknowledgement of the LGBTQIA+ community's right to live with dignity and make choices about their intimate relationships set the stage for a broader consideration of their rights in the subsequent cases. Secondly, Chief Justice Deepak Mishra delivered the judgment in Navtej Singh Johar, emphasizing the importance of inclusivity, equality, and non-discrimination. The court in Navtej Singh Johar held that the LGBTQIA plus community is entitled to the same constitutional rights as any other citizen, and any discrimination based on sexual orientation is a violation of their fundamental rights. This principle of equality before the law, enshrined in Article 14 of the Constitution, became a cornerstone for arguments advocating for the recognition of the same sex marriage rights in the Supriyo case. Furthermore, the Navtej Singh Johar judgment marked a departure from the traditional norms and societal prejudices by recognizing the diversity of the sexual orientations and identities. This recognition of diversity and the dismantling of stereotypes related to sexual orientation provided a basis for challenging societal norms that might have influenced the majority opinion in the Supriyo case. However, despite the influence of the Navtej Singh Johar judgment, the Supriyo case also revealed a significant judicial divide. The majority opinion, led by Justice S.R. Bhatt, Hema Kohli, and P.S. Narasimha, expressed reservations about extending the right to civil unions and adoption to the LGBTQIA community. This divergence highlighted that while the Navtej Singh Johar judgment set a transformative precedent, there were differing interpretations and applications of the LGBTQIA rights within the judiciary. In contrast, Chief Justice D.Y. Chandrachud and Justice S.K. Kaul, forming the minority opinion, took a more expansive view of the LGBTQIA rights. They went beyond the baseline established in the Navtej Singh Johar judgment, affirming the right to enter into abiding unions, adopt, and receive various entitlements arising from such relationships. The minority opinion sought to bridge the gap between formal equality and substantive equality, emphasizing that mere decriminalization was not enough and that the state had an obligation to recognize and protect the rights flowing from the intimate associations. Thereby, the Navtej Singh Johar versus Union of India judgment undeniably formed a legal precedent that influenced the Supriyo versus Union of India case. The recognition of right to privacy, equality, and the rejection of stereotypes in Navtej Singh Johar provided a foundation for arguments in favor of the LGBTQI plus rights in the Supriyo case. However, the dissenting opinion in the Supriyo judgment also highlighted the ongoing challenges in achieving full recognition and protection of their rights within the Indian legal framework. The tension between majority and minority opinions in these cases reflects the broader societal debates and the evolving nature of the legal interpretations concerning the LGBTQIA rights in India. Now, we move on to the third question of today's discussion, which is reflecting upon both Supriyo versus Union of India and updates in Johar versus Union of India. What is the future trajectory of marriage equality within Indian jurisprudence? I'll also take this question. The trajectory of marriage equality within the Indian jurisprudence, as reflected in both the Supriyo and Navtej Singh Johar judgment, presents a complex interplay of legal interpretation, societal norms, and evolving perspectives. While the Navtej Singh Johar case marked a significant milestone by decriminalizing consensual same-sex relations and establishing the foundation of recognizing the LGBTQI plus rights, as discussed in the previous question, the subsequent Supriyo case demonstrated the challenges and divisions between the judiciary regarding the extension of marriage rights to the LGBTQI plus community. The future trajectory of the marriage equality within Indian jurisprudence is likely to be influenced by several factors. Firstly, the acceptance and understanding of the LGBTQI plus rights in India in Indian society are evolving, even though this evolution is gradual. As societal attitudes continue to change, there may be increased pressure on the legal system to align with more progressive perspectives. The public discourse, advocacy, and education play crucial roles in shaping these attitudes over time. Secondly, the Navtej Singh Johar judgment set a precedent by recognizing the constitutional rights of the LGBTQIA plus community, including the right to privacy and equality. However, the dissenting opinions in the Supreme case revealed differing judicial philosophies within the Supreme Court. The future trajectory will depend on how the subsequent cases build upon or deviate from these precedents. Furthermore, while the judiciary plays a vital role in interpreting and upholding rights, the legislative reforms are equally important. The Indian Parliament has the authority to enact laws that explicitly recognize and protect the rights of the LGBTQIA plus community, including the right to marry. The legislative initiatives can provide a more comprehensive and enduring framework for marriage equality. Also, the global trends and international human rights standard may also impact the trajectory of the marriage equality in India. The judiciary may consider decisions from other jurisdictions and international treaties advocating for the LGBTQIA plus rights and shaping its interpretations. Furthermore, the ongoing advocacy and activism by the LGBTQIA plus community organization, human rights groups, and allies are instrumental in fostering awareness and pushing for legal reforms. Even though the Supriyo judgment did not do much for the community itself, but still the the minority opinions by the Chief Justice of India and Justice Kaul contributed to the awareness regarding the rights of the LGBTQIA plus community. And continued efforts to challenge discriminatory practices and promote inclusivity can contribute to a more favorable legal environment in the future. Furthermore, the public opinion and political will to address these rights issue itself are they significantly influence the direction of the legal developments. The political leaders and policy makers may respond to changing public sentiment by championing the legislative changes that support marriage equality. Lastly, the trajectory of the marriage equality may also intersect with broader issues of social justice and human rights, recognizing the diverse needs and experiences within the LGBTQIA plus community, including issues related to gender identity, may lead to a more comprehensive legal framework that goes beyond mere discrimination. In contemplating the future trajectory, it is essential to recognize that the legal developments are dynamic and can be influenced by a combination of these factors. While the Supriyo case represents a setback in terms of explicitly recognizing the right to marry for the LGBTQIA plus community, the dissenting opinions emphasize the potential for a more inclusive interpretation of the constitutional rights. Ultimately, the path towards marriage equality in Indian jurisprudence will likely be marked by ongoing legal battles, the legislative initiatives, and the societal shifts. The intersection of these factors will determine whether the future judgments align with the principles of equality, non-discrimination, and the protection of the fundamental rights for all individuals, regardless of their sexual orientation or gender identity. Now we move on to the fourth question, which is essentially discuss the plausible implications of both the Supriyo versus Union of India and the Navtej Singh Johar versus Union of India verdicts on the broader spectrum of family law in India, particularly in areas like property inheritance, custody rights, and divorce proceedings.
I would be taking up this question, and I would start with the so beyond the specific legal areas, the Supriyo judgment as well as the Navtej Singh Johar judgment have broader societal implications by recognizing same-sex relationship. They foster visibility and acceptance for LGBTQ plus families, potentially leading to reduced discrimination and promoting positive social change. This shift in social attitudes is crucial for building a more inclusive and equitable society for all. The legal precedents set by these verdicts are also significant. They provide a strong foundation for future legal challenges and reforms aimed at securing equal rights and protection for LGBTQ plus individuals as well as families. These precedents empower legal professionals and activists to advocate for challenges and push for a legal framework that recognizes the diverse realities of families in India. However, the challenges remain. The legislative action is needed to enact specific laws addressing marriage, inheritance, custody rights, and other family law issues for the same sex couples. This requires a concert effort from legislators, legal professionals, and civil society organizations to ensure that the legal framework evolves alongside the changing societal landscape. So, I would be talking about inheritance first. So, the Navtej Singh Johar versus Union of India decriminalized same sex relationships, indirectly paving the way for LGBTQ plus community and their legal recognition. However, it does not openly talks about inheritance as such, though it opens doors for future legal challenges and reforms aimed at granting same sex couple inheritance rights on par with the heterosexual couples. While it does not directly address the issue, the Johar verdict fosters a legal framework that acknowledges the LGBTQ plus rights, potentially influencing future inheritance related legal development. In the Supriyo judgment, even though it denied legal recognition to the same sex marriage, it created a hurdle for property inheritance as per the family law norms exist pre-existing family norms without legal spousal status. The same sex partners may struggle to inherit properties from their deceased partner, especially under the intestate succession rules. And this lack of recognition creates significant financial insecurities as well as potential legal battles for LGBTQ plus families. As far as the custody rights are concerned, again, as the Navtej Singh Johar case does not directly address custody rights. However, its recognition of LGBTQ plus dignity and fundamental rights may influence future legal developments regarding custody arrangement. This potentially encourages the court to consider the child's best interest without prejudice against the LGBTQ plus parent, ensuring a fair and equitable custody decision. In the Supriyo judgment, it leaves the same sex couple vulnerable in separation scenarios, as without the legal marriage recognition, there are no clear guidelines for custody arrangement, potentially leading to discrimination and challenges for the LGBTQ plus parents seeking custody of their children. And as in the absence of legal recognition, it creates an unstable environment for families and raises concern about their best interest of the child being disregarded due to paternal sexual orientation. As now, the divorce proceeding, the Supriyo judgment leaves same sex couples without any legal avenue for divorce. The lack of legal recognition for the same sex marriages creates a legal vacuum for divorce proceedings, leaving the couples with limited option and potential legal complexities in case of separation. This lack of recourse can lead to emotional distress, financial hardships, and prolonged legal battles. The Navtej Singh Johar case sets a crucial precedent for recognizing the legitimacy of the same sex relationships. This paves the way for future legal reforms addressing divorce proceedings for the same sex couples, potentially allowing for equitable division of assets and protection of their rights during separation. However, I would like to point that all of this is dependent on the legislative action, and ultimately, the journey towards a more inclusive and equitable family law landscape requires a multi pronged approach. Legislative action, as well as judicial interpretation and social advocacy, along with public education, are essential components for the long term process. A legal framework that recognizes and protects the rights of all families, including regardless of the sexual orientation, would be would be essential to ensure a brighter future for LGBTQ plus individuals and families in India. That's it.
Um, I'll be taking the question. Thank you. To move on to the next question, given the socio-cultural context of India, how potent was the Supreme versus Union of India judgment in shaping the public opinion regarding marriage equality? The judgment of Supriyo versus Union of India undoubtedly carries a significant weight in shaping public opinion regarding marriage equality in the distinctive socio-cultural context of India. The multifaceted impact of this legal decision is deeply intertwined with the country's diverse traditions, cultural norms, political dynamics, and the ongoing struggle for the LGBTQI rights. Firstly, discussing the cultural dynamics, India's cultural
diversity and deep-rooted traditions are integral to its societal fabric. The judgment which denies the same-sex couples the recognition to fundamental right to marry has potential to resonate with conservative cultural values that often perceive marriage through a heteronormative lens. The prevailing cultural norms, heavily influenced by traditions and religious beliefs, may resist embracing non-heteronormative relationships as a part of marital institution. Now, coming to the influence of on social attitudes, the public opinion in India is shaped by a complex interplay of social, cultural, and legal factors. The denial of right to marriage for same-sex couples may contribute to the perpetuation of societal stigmatization against the LGBTQI community. Deep-seated social attitudes, which are often resistant to change, might be further entrenched by the legal pronouncement, potentially hindering progress towards greater acceptance and understanding as well. Now, the symbolic significance of marriage. Marriage in India is not merely a legal contract, but also holds a profound symbolic and cultural significance, as we already know. The judgment's denial of this right to the same-sex couple may inadvertently reinforce societal perceptions that such unions deviate from established cultural norms. This symbolic dimension has the power to influence public opinion by framing the discourse on marriage equality within the broader cultural social context of the India. LGBTQ activism and community response. The legal setbacks is one of the case that has been presented by the judgment, and it can serve as a catalyst but for the heightened LGBTQ activism, for the for the denial of rights and the community mobilization. The denial of fundamental right to marriage may galvanize the community and its elites to engage in more visible and vocal advocacy efforts. This activism can contribute to reshaping public opinion for fostering awareness, dispelling myths, and fostering a more inclusive narrative on marriage equality. Coming to political and media amplification that the case can face, public opinion in India is significantly influenced by political discourse and media narratives. The judgment framing of the right to marriage as not constitutionally guaranteed may resonate through political and media channels. How political leaders and media outlets interpret and communicate the legal decision can significantly impact public attitudes. A lack of supportive political discourse or media coverage may impede the growth of more progressive views on marriage equality. Now, coming to legislative landscape and public perceptions, public key is a key driver of legislative reform. The judgment stands on the absence of fundamental right of marriage could impact the potential political will to enact law recognizing same-sex unions. Legislators attuned to public sentiment may be hesitant to champion marriage equality, especially if they perceive that it goes against prevailing societal attitudes influenced by the legal pronouncement. Thus, the judgment within the complex socio-cultural landscape of India has far-reaching implications on public opinion regarding marriage equality. Its impact extends beyond legal dimensions, influencing cultural perceptions, societal attitudes, activisms, media narratives, and the broader discourse of LGBTQI rights in the country. Understanding the impact requires a nuanced examination of the interplay of these legal decisions and the intricate layers of India's diverse cultural tapestry. Thank you.
Thank you so much, Subi. Now we move on to the last question for the day. How does the Supriyo versus Union of India case reflect or discuss international legal trends regarding the marriage equality?
Yeah. Now I'll be going into. Am I audible, please? Right. I'll be exploring
Definitely
how
audible.
the Supreme v Union of India case reflects or discusses international legal trends regarding marriage inequality and so on. So, firstly, regarding marriage equality worldwide, it is pertinent to note that over 30 jurisdictions in the world since Netherlands in 2001 have legalized same-sex marriages, currently about 34 to be precise. However, regarding the interactions with questions such as international law and the Bill of Rights, including the International Convention on Civil Covenant on Civil and Political Rights and the UNUDHR, it is worth noting that marriage pleas fall into three categories among jurisdictions. Firstly, jurisdictions may lack meaningful engagement with international law. Secondly, they may place reliance on treaty obligations and comparative law for their decisions. And thirdly, jurisdictions may insist on compliance with decisions of bodies established by international human rights instruments. This may include the American Court of Human Rights and the European Court of Human Rights. Now, a majority of countries, however, have gone down the first route, which is they have legalized same sex marriage by dint of judicial decree rather than referencing any kind of international obligations to the same. For instance, even in South Africa's constitutional court's examination of international law, it just concluded that there was nothing in the content of law to preclude legalization of same sex marriages. And therefore, it inferred that international law granted its countenance only the right of solemnizing heterosexual marriages. As a result, a crucial opportunity to scrutinize non discrimination obligations under international law, human rights instruments, was therefore lost once again. Again, even the American Court of Human Rights has gone, however, gone into the question of whether equality to marriage can be granted by the relevant covenants and have answered in the positive. However, to the contrary, the International Covenant on Civil and Political Rights, to which India is party, has not had a history of case law propitious for the prospect of granting same-sex marriage rights. Now, interpreting Article 23 of the ICCPR regarding equality of marriage over Article 26's non-discrimination requirement, the Human Rights Committee of the United Nations in Jocelyn versus New Zealand had held that New Zealand had not infracted the ICCPR by failing to provide recognition to same-sex marriages. The UNHRC in the case wrote that the term men and women, rather than general terms used elsewhere, had been consistently and uniformly used, indicating that the covenant only intends to recognize the union between a man and woman wishing to marry each other. However, several jurisdictions across the world have taken a slightly different approach, and this can boil down to the wording of the article itself. Now, Article 23.2 of the ICCPR states that allows for equality of marriage of men and women of full age. Now, whether or not this includes between men and women of full age and an inter-se relationship is still unclear. And several commentators and scholars have noted that such an inference cannot be drawn. Now, the inconclusiveness of international law obligations vis-a-vis same-sex marriage notwithstanding, it the express mention of men and women in marital rights clauses can easily be interpreted to confer a right of every man or woman to marry, as opposed to asserting that the right of every man to marry and a woman to marry and vice versa. Moreover, the non-discrimination requirement under Article 26 of the ICCPR can hold precedence in recognizing the sheer gender spectrum that may be that ought to be recognized, and which, even in the case of Navtej Singh Johar versus Union of India, this diversity has been recognized. Secondly, with the contemporary tide of favorable decisions by national courts and regional judicial bodies, these developments can be understood as altering the treaty obligations under the ICCPR, placing an international law obligation on civilized nations, which is gradually materializing into a custom. Moreover, in the Indian context, with regard to international references in the Supriyo versus Union of India case, it is worth noting that despite several times in the past, including Vishaka v. State of Rajasthan, where the court has used international norms to interpret statutory provisions and identify enumerated fundamental rights, commentators have noted that in this particular case, it seems to be an opportunity missed. Now, the ratio of holding that the right to marry as is not a fundamental right runs contrary to the accepted position of the right to marry as a human right under international humanitarian law. Moreover, it is worth noting that even in the early 1990s, the court relied upon both the UDHR and the ICCPR, both of which allow for such a right to marry in several cases regarding Article 21. Now, paradoxically, the Chief Justice too did not engage with the UDHR or ICCPR while delving into the nature of the right to marry. However, in the latter part of his opinion, he relies on these provisions of international covenants to prohibit conversion therapies or other treatments under the purview of Article 5 of the UDHR and Article 7 of the ICCPR. Now, this selective use of international norms to suit according to the popular opinion does not bode well for the rule of the law. Thus, this indicates that international law in general has furthered a judicial current towards the establishment of same sex marriage as valid under international human rights law. And it is for this reason that several of those dissenting the opinion as stated, although this is although the court did not share the opinion regarding the applicability of international law, several individuals have dissented against the same. And this specifically boils down to the recognition of same-sex marriage under humanitarian law, and which has been followed by several countries in the past and is in the process of being recognized by countries in the future.
Thank you so much, Akshat. This brings us to the end of our discussion. Thank you, everybody, for your active participation and thoughtful contributions to our discussion on the Supriyo versus Union of India case. Our deliberations have provided valuable insights into the multifaceted dimensions of the legal, societal, and contextual aspects surrounding the LGBTQIA plus rights, as highlighted by the recent judgment. The diverse perspectives shared by our panel have enriched our understanding of the complexities inherent in the Indian legal framework. The discussion has proved to be extremely helpful and informative, and I look forward to future collaborations that contribute meaningfully to the progression of the rights of those who have been historically marginalized within the legal fabric of our nation. Thank you.
Thank you everyone for joining. I will just stop the recording.
Thank you.
Thank you.